Okay, let me talk to you for a minute, all right? There are some things that I was asking some questions about, okay, people were asking me about, so I'm trying to put things together. Okay, legal penalties for violating the rules of professional conduct. This is what they'll tell you. Violating the rules of professional conduct does not automatically lead to criminal charge or civil lawsuits, as these codes primarily regulate professional license. However, violations can result in professional discipline, disqualification, or even criminal and civil liability, depending on the severity and the nature of the misconduct. Okay. And let's go there again. Okay, legal penalties for violating the code of judicial conduct does not usually result in traditional civil liabilities, as judges have judicial immunity for their rulings. Instead of judges face interjudicial disciplinary actions like reprimands, suspensions without pay, or removal from office. Okay, so people ask me, how can you prove that these lawyers and judges, violated the rules of professional conduct and the code of judicial conduct? Well, that's easy once if you read them, because that's their job descriptions. Nobody can knowfully and willingly defy your right to due process. Effective assistance of counsel. They took the oath to do that. So violating the oath is they you know they took the oath to the Constitution. Nobody can violate the oath. Okay, what is it called when judges and lawyers work together? And they work together because they're supposed to enforce and report any violations of the rules and codes. It's mandatory to report misconduct, and nobody does it. And nobody abides by the rules or the code, so it's easy to prove that they didn't do their job, and it's impossible for them to prove they did. When a judge and lawyers work together to bypass ethical rules and manipulate the legal process to deny a fair trial, it's referred to as judicial and legal misconduct, collusion, uh, or a violation of due process rights. Ex parte communications, that's how it always happens. Judicial bias, there's always judicial bias. I seen that campaign, Don't Say Gay, but if you look in the preamble, the Code of Judicial Conduct, that's saying that's bias, prejudice, nobody can make such laws, violates the rule of law. It doesn't matter if they're gay, married, their color, their religion, their political affiliations, even their gender identity. That is discrimination, and judges and even lawyers are supposed to be unbiased. Collusion or conspiracy. So this is what gives you conspiracy against rights under the color of law, because they work together simply by not abiding by the rules and the codes, and it's mandatory to report this misconduct. They're supposed to be watching each other, making sure everybody does that and nobody's doing it, and they see it. And okay, so it says right here, Sixth Amendment guarantees the fundamental rights of an individual access to of accused of crimes, ensuring a fair trial in the American legal system. Ratified in 1791, it mandates the right to a speedy trial. That doesn't even exist. Look up quick and speedy trial. There's limitations on that. And I met so many people that went to jail, didn't have that, went to prison, and they could get out right now simply because they didn't get a quick and speedy trial. Look up the limitations on a quick and speedy trial, or just look up quick and speedy trial. It'll tell you. It mandates the right to a speedy trial and public trial, and an impartial jury, and assistance of legal counsel, and those requirements are in the rules of professional conduct and the code of judicial conduct, and ability to confront witnesses. The exact term ensures that in all ethical prosecutions, accused shall enjoy the following specific protections. Speedy and public trial protects defendants from indefinite secret or prolonged incarceration before their guilt is proven. Okay, so it says right there, protects the defendants from secret. So and plus the public has the right to know what's going on. So the public has a right to a public trial. Impartial jury ensures the trial is decided by a represented group of citizens from the state and district where the crime was allegedly committed. Right now, I'm in court for eviction, and I picked a jury trial because I know judges won't abide by the code of judicial conduct, and the lawyer that's putting me through this is violating the rules of professional conduct. It's just legal harassment, and that's forbidden. It says so in the preamble of the rules of professional conduct. Notice of accusation, give defendants the right to be informed of the nature of cause of the charges against them. They did, but they limited. They just said they're suing me. First, it was because I wasn't paying rent, but I can verify that. I have bank statements, etc. So then went to I refused to pay the increase in rent. They bought the building, they raised the rent, and I refused to pay the increase. I refused to pay the increase because they refused to make the mandatory repairs, and I discussed the laws going over that with them. So instead of doing all the repairs, it's cheaper to go through the legal process and have me evicted. The lawyer said he knew the judge. All he had to do was give her a call, and she won't let me. They'll make it so I can't get this before a jury because I picked my own jury. I've helped other people in criminal cases and a few civil cases where I told them to take a jury. You can't trust the judge. I went over the rules. Nobody's done this so far. The only chance you have is with a jury. And pick your own jury. You have a right to pick a jury of your peers. They won't bring anybody in there, but at least you can talk to these people and find out what kind of background they have, issues they've been through, if they were similar. You want to pick people that live issues like you've lived issues. If you let the lawyers and the judges pick the jury, they're going to pick ones that that are more likely to be compelled to see their way of thinking instead of the way, the truth of what you're going through. Compulsory process allows the accused to compel favorable witnesses to testify in their behalf often via subpoena. Assistance of counsel guarantees the right to legal representation on the Supreme Court President. The defendant cannot afford an attorney. The government must provide one for them. Okay, so complete breakdown. Okay, so they all knowfully and willing conspire to deprive you of your rights. So that's where you get this. Conspiracy against rights under color of law involves two or more people, individuals agreeing to interfere with someone's constitutional or federal statutory rights while acting under actual or apparent government authority. This is severe federal offense, frequently prosecuted by the Department of Justice. The offense directly violates key federal civil principles. Okay, so I'm quite sure you've seen my other videos, hopefully, and not just stuck on one, that I talk about this a lot. And remember, knowingly and willingly deprivation of rights disqualifies that immunity that judges are supposed to have. They can make a mistake in the decisions that they made about what you were going through in the case and not be sued for that. But knowingly and willingly depriving you your right to a fair trial because they neglected to abide by and enforce the code of judicial conduct and the rules of professional conduct, and your lawyer was ineffective assistance of counsel, the judge didn't cite them and report them to the proper authorities, thus creating conspiracy against rights under the color of law. Okay, because of mandatory reporting misconduct, any lawyer or any judge that knows of any lawyer or any judge violating or attempting to violate the rules of professional conduct or code of judicial conduct, it's mandatory to report that misconduct. Failure to report misconduct is misconduct, thus depriving you your right to effective assistance of counsel. Fair judiciary. Look up Rule 3.8, Special Rules of the Prosecutor. It tells you that they can't go forward a case that they can't prove. They have to have probable cause, and they'll take you to court without probable cause, and if you don't agree to taking their cop out, then they start throwing more charges at you, and they usually wind up violating your right to a quick and speedy trial to do that. You don't know it, and they take advantage of your ignorance of the law, and then later on, when you find out, they'll say, hey, it's your fault. Ignorance of the law is no excuse. You should have known that. Look up ignorance of the law. But the whole way to unravel that tangled web you're in is with the law. So I'm telling you what you've been going through. They have examples in here. It's just there's a statute of limitations. I doubt that. And if it was, it wouldn't be in the public interest. Statute of limitations of rights under the Colorado Department with a criminal charge or civil lawsuit. For criminal charges under USC, it's typically 5 to 7 years. For lawsuits, it generally ranges from 1 to 4 years, depending on state law. Under 7 years for offenses not resulting in death, the statute of limitations is generally 5 years, but it can be extended to 7 years under specific civil rights provisions. No statute of limitations if deprivation results in death. Rights results in death. This is a criminal statutory enforced by the Department of Justice or the FBI, not private rights or actions of victims. Not in the public interest means an action, disclosure, or decisions harms, ignores, or fails to benefit the welfare of the general society is commonly used in legal, government, and journalist context to justify withholding information, declining or to prosecute a crime, or blocking private projects. Okay, so them slapping you with a statute of limitations on something you just found out about. They're going to tell you, but see, they will do a lot of laws that are not in the public interest. Okay? Let me give you the number one reason they can't do that. Foundational rules of the rule of law is a foundational principle. Individual, institutions, and government itself are accountable to laws that are specifically promulgated, equally enforced, and independently adjudicated. Ensures that no one is above the law and guarantees fundamental rights, fairness, and non-arbitrary governance. This concept is built on 4 universal principles. Accountability, both government and private actors are answerable to the law. Just laws that are clear, publicized, stable, and protect fundamental human contract and property rights. Open government, the process by which laws are enacted, administered, and enforced, are accessible, fair, and efficient. Impartial justice. Justice is delivered timely by competent, ethical, and independent representatives and neutrals. So, judges and lawyers knowingly and willingly violating the rules and the codes is deprivation of rights. And the only way you're going to know all this is if they told you that you didn't know, but they're going to use your ignorance of the law against you, which is not in the public interest because it violates the rule of law. The statute of limitations being held upon you, but yet still letting all these lawyers and judges violate your right to effective assistance of counsel, a fair trial, or due process, a quick and speedy trial, wholeheartedly denied, knowingly and willingly, in defiance of their job descriptions, the rules of the codes. And they're going to tell you ignorance of the law is no excuse, but you're going to have to remember who you are. We the people. You are the public. They created a law that was not in the public interest. It violated the rule of law. It was in, oops, sorry. Distinction between in the interests of the bar and the public interest highlighted long-standing tensions in the legal profession. The bar prioritizes self-government, professional reputation, and economic protection, whereas the public interest demands broad access to quality legal service and protection of civil rights. Well, let's go to right here. The legal profession's relative autonomy carries it with special responsibilities of self-government. The profession has a responsibility to ensure that its regulations are conceived in the public interest, not in further of parochial or self-interest concerns of the bar. Every lawyer is responsible for observance of the rules of professional conduct. A lawyer should also abide in securing their observance by other lawyers. Neglect of these responsibilities compromises the independence of the profession and the public interests which it serves. Okay? That's pretty good to know, right? So you should read the rest of this too. Now I want to go to... Okay, preamble. Okay. I use that. Maintaining the integrity of the profession. Okay. Misconduct. It is professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct, knowingly or assist, induce another to do so, or to do so through the acts of another. Commit a criminal act that reflects adversely on the lawyer's honesty. See, so there's a lot of stuff you can say. You just copy and paste when you're filing your complaint. Okay, so there's a lot of misconduct up there. Disciplinary authority. That's where they hit it. A lawyer, no, wrong one. Where is it? Misconduct, maintaining the integrity. Here it is, 8.3, reporting misconduct. A lawyer who knows that another lawyer has committed violations of the rules of professional conduct or raises a substantial question as to the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects shall inform the appropriate professional authorities. A lawyer that knows a judge has committed a violation of the applicable rules of Code of Judicial Conduct is a substantial question as whether the judge fitness shall inform the appropriate authorities. Okay, so nobody's reporting each other. Everybody's violating the rules, the codes. Nobody's diligent in expediting litigation. Nobody's communicating any of this to you. and responsibilities. A subordinate lawyer, they can't say, "Yeah, I was just taking orders from the boss," because taking illegal orders, giving illegal orders, unlawful orders it's illegal. And what are they going to claim? Ignorance of the law? They'll use it on you. How's it going to work on them? Truthful statements to others, talks about honesty, integrity, and all that other. But, make false statements. See, if in the course of representing a client, a lawyer shall not knowingly make false statement of material fact or law to a third person. Failure to disclose material fact to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client unless disclosure is prohibited. But they don't care because you don't know, so they're counting on your ignorance of the law. You're not knowing, and I'm just telling you, you're finding out now. And I was telling you about special rules of prosecutor. People ask me about, okay, the prosecutor shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. And but it doesn't matter what court it is, criminal, civil, whatever, it's the same goes for every court. It's just that they're being very specific with the prosecutor, but you go through the rules of professional conduct in its entirety, and it tells you in the preamble that moving forward a case that is not supported by probable cause shouldn't even be brought into court. But lawyers, of course, still let it in. Then the other side got to get a lawyer, and they go back and forth with all this drama, all this theater, and costs you a lot of money, but it's mandatory to expedite litigation. It would be diligent, and those are, two laws that we haven't even reached into. Okay, but there's a lot of things they don't do, so, fairness to the opposing party and counsel, that never happens. A lawyer shall not will unlawfully obstruct another person's access to evidence, or will unlawfully alter, destroy, or conceal a document. And that's how that's how wrongful convictions are committed. Nobody's doing this. Nobody's paying attention. But so it's up to you. Expediting litigation, right? I told you about that, right? Lawyers shall make reasonable efforts to expedite litigation consistent with the interests of the client. Okay, that was a pretty good one, right? Pretty short, right? Okay, lawyers shall not knowingly make a false statement of fact or law in a tribunal, or fail to correct false statements of material fact or law previously made tribunal, so fail to disclose to the tribunal legal authority in the controlling jurisdiction known as the lawyer to be directly adverse to the position of the client and not disclosed by opposing. So it's not happening. Candidates tribunal, meritorious claims and contentions, and that doesn't happen. Lawyers shall not bring forth or defend a proceeding or assert or convert an issue therein unless there is a basis in law or fact for doing so that is not frivolous. And they'll do it anyways because they know the other guy, is going to say, okay, let's drag this out. We got some billable items here. So people, it's just, they ain't going to do none of this if you don't know. I have people get mad at me. Well, they know that's their job. Why ain't I doing it? Because they know you don't know what their job is. And, what are you going to say? Do your job? When you don't, and they're going to say, okay, what do you want me to do? And I would tell them, let's expedite that litigation. Yeah, but you got to understand the other guy. And I said, I got my car. Come on. Let's go. Due diligence. Let's go over. We're just marching that off and say, give me my shit. And then they get mad at me, But it's the law. You can't. In fairness to the opposing party, expediting litigation would be competent. Oh. I mean, any fees are unnecessary. Look, it's supposed to be diligent, right? So diligent, this is the law. Can't break the law. Lawyers shall act with reasonable diligence and promptness in representing a client. That's all it says. Look at that's so hard to remember what diligence means. Okay. Scope of representation and allocations. Competence. A lawyer shall provide competent representation to a client. A representation requires a legal knowledge, skill, thoroughness, and preparation reasonably necessary for representation. Competent representation would surely mean being diligent. Being diligent would be competent. Being diligent in expediting litigation would be competent. Communicating with you that it would be diligent, and competent, expediting litigation. So it's impossible just to violate one rule. Remember, reporting misconduct is mandatory. Even they don't have to be involved in the case, just the general knowledge, watching it on TV, just having the general knowledge. And, I mean, if you're one of those auditors, you want to mess with attorneys, take a copy of the rules of professional conduct and memorize them, and take them with you, carry them with you, so that way you don't have to open your phone and ask them, did you ever violate the rules of professional conduct? And, I've been going over this, and, you guys don't do this. None of this. What the hell is wrong with you? And you read the preamble and the scope, it just makes them look ridiculous. A lawyer is a member of the legal profession, is a representative of clients in the legal system. Okay, I just want to get to some. See, it says right here, as an advocate, a lawyer zealously asserts the client's position under the rules of the advisory system. A negotiator lawyer seeks the result advantageous to the client, but consistent with the requirements of honest dealings with others. As an evaluator, a lawyer acts with examining a client's legal affairs and reporting about them to the client or to others. In addition to these representational skills, a lawyer may serve as a third-party neutral. And look, it says for a lawyer who commits fraud in the conduct of their business is subject to discipline. A lawyer's conduct should conform to the requirements of the law, both in professional service to clients and in a lawyer's business and personal affairs. A lawyer should use the law's procedures only for legitimate purposes and not to harass or intimidate others. A lawyer should demonstrate respect for the legal system and those who serve it, including judges, others lawyers, and public officials, while the lawyer's duty, when necessary, to challenge a rectitude of official actions. It is also the lawyer's duty to uphold the legal process. So there's a lot of stuff they don't do in here, and it's going to upset you. But at the same time, by the time you get done with yourself, learning the rules of professional conduct and the code of judicial conduct, people, I keep telling you, that's the tip of the spear. That's how you get in and through the courtroom. And remember to apply the letter of the law, And these are your weapons, and nobody's doing it, and this is a conspiracy against rights under the color of law. This is deprivation of rights. This is violating the rule of law. This is violating the oath. This is depriving you as a U.S. citizen of your birthrights, your constitutional rights. You're supposed to be free. They took the oath to do this, and they're not. So right now, you just proved to yourself your rights aren't a given, they're earned. Time to earn your rights. Good night, y'all. May your Creator always be with you and rain many blessings. Long life and good health.